I was recently asked why I put so much time and effort into speaking about New Zealand's national security. The same reason you should, I replied. For our children, nieces, nephews and their children. Hi, I'm Simon Ewing-Jarvie. It's our responsibility to leave a better, safer, freer country than we inherited, and the only way that's going to happen is if ordinary citizens are involved in the national security conversation. That conversation should start with a comprehensive national security strategy being formulated, not the compartmentalised and under-resourced thinking which has been allowed to take hold, because that is indefensible, New Zealand. Welcome back to episode 6 of Indefensible New Zealand, and today we're going to talk about some legal changes that I think would make sense in the national security environment. Let me start by saying I'm not a lawyer, something that I think will be of great comfort to New Zealand's legal profession. But I can see where changes are needed, and I can see where ideas that I'm talking about here need legislative support. First, we've got a question from an audience member, and it's about the New Zealand Defence Force's COVID-19 support called Operation Protect. And the question is about how long is the New Zealand Defence Force going to be involved? The answer is, I don't know, and neither do they. And that's not a good situation for them to be in. Imagine going into a peacekeeping environment without an exit strategy or some definition in advance of what success will look like so you know when it's time to pull out. To the best of my knowledge, there is no exit strategy for the New Zealand Defence Force from Operation Protect other than when the government decides they want to do something else. Now, that's not acceptable. The Defence Force is a very scarce resource, and whilst I'm absolutely in favour of them being involved as a first responder for COVID-19 in relation to helping to secure the borders, deploying medical staff and so forth, there is simply no case for having soldiers, sailors and airmen sitting around in hotels carrying bags and taking people out for exercise walks when we've got 27,000 licensed security guards in New Zealand. So come on, government, step it up, and Defence Force, you need to be rattling that sabre a little bit more and making it clear to the politicians that you've done your thing now and you need to be thinning out, getting yourself back into the cycle of preparation for other emergencies. Now let's get back to the law. I've got a few points that I want to raise today, and the first one just harks back to the previous episode and the Royal Commission of Inquiry into the Christchurch shootings recommendation that we have a national security agency and the chief executive becomes the primary or national security advisor to Parliament. That clearly is going to require some legislative support, and the title, it's the obvious one, is already taken. In 2017, the New Zealand Parliament passed the Intelligence and Security Act, and this came from a March 2016 report by Sir Michael Cullen and Dame Patsy Reddy, and it really was about the GCSB and NZSIS, who had their own pieces of legislation, 4 pieces in all, and how to bring together the New Zealand intelligence community to work together better. What do we need in terms of legislation here? Well, we need legislation that will raise a national security and intelligence agency. We need that to create the chief executive as an officer of Parliament. It should require a strategy for national security and a national threat assessment to be delivered, and it should focus on New Zealand becoming self-reliant. Logically, that would mean an end to defence white papers and a national security white paper being produced every 5 years as a minimum. Does it need a new act, or do we simply need to amend the current 2017 legislation to look beyond the New Zealand intelligence community? Matter for another day. I'll see who we can get on to talk about that in another episode. Secondly, let's talk about natural disasters and New Zealand's defence. We've got the National Emergency Management Agency, and it's outside DPMC. You spot the pattern here. I commend the Lifelines Council's 2020 annual report to you. Now, the Lifelines Council is responsible for looking at all the transport, energy, communications and water services that are fundamental to New Zealand's communities and the economy. That's largely a natural hazard focus, but remember, if something is extremely important to New Zealand and is vulnerable to natural disasters, it's also going to be a prime target in a hot war. So there's going to be some crossover, I foresee, in the future between legislation enabling the National Security Agency and some of the work that the Lifelines Council is doing. At the moment, when a bill goes to Parliament, it's accompanied by a regulatory impact statement. Now, these have morphed over the years and are now becoming more and more comprehensive. They're lodged with the bill or before the first reading, and they're then made available with the explanatory notes and so on to both members in the House and to select committees. I think a national security impact statement is an essential element of ensuring that people are thinking about the unintended consequences, particularly of making changes to law that might make perfectly good economic sense or social sense, but actually are disastrous for our self-reliance as a country, our resilience, or our ability to protect ourselves from an external threat. It's a very, very simple mechanism for having people think about the future and about New Zealand's national security when each bill goes into the House. The next piece of legislation I want to talk about is the Armed Forces Covenant Bill or Act, and I've deliberately used armed forces, not defence and not veterans, for the same reason I'm talking about national security. Those people who put themselves in harm's way to protect others are a unique type of citizen, and nowhere have we ever really documented, other than with a nudge and a wink, the social contract that exists between society and the people who protect it. Now, I've written about this on my blog. There are some people who would criticise this and say, well, it sets up two classes of citizen. Well, that's true, but also irrelevant because there's already two classes of citizen. There's those who put themselves in danger to protect others, and then there's the rest. So the Covenant Act would set out the social contract between the state and the individual, both during service and after service. Now, there's been various attempts around the world. The UK had one, just fell short of passing it into legislation. Australians likewise have come up with a non-legislative approach. I don't think it actually works, and the reason for that is I've seen how employers have worked their way around the issue of having reservists in their workforce. Some are hugely supportive and some are not. We need a legal framework on which service personnel leaving the force particularly can rely on. Veterans Affairs New Zealand is the entity that's responsible for looking after our veterans. At the moment it's part of the New Zealand Defence Force. That is absolutely the wrong place for it. For a start, only some veterans are part of the Defence Force. The question really arises, who is a veteran? I think VANS would be better off as an independent Crown entity. It's a simple legislative change with their own appropriation. But we do need to wrestle with this legal construct of what is a veteran, and we're going to spend several episodes throughout the podcast talking about veterans and what support they do get and what they should get. But at the core of it is, what is a veteran? Now, there's been ministerial advisory groups talking about this in the last Parliament particularly, and various other groups before that. The problem is it never goes anywhere. And while we've got a veterans portfolio being held by a minister outside cabinet, it's not likely to go very far either. So we need a holistic approach. You can call it a kawanata if you want to, but it still doesn't change the fact that nothing much is being done other than people talking, reports being made, recommendations being made, and then no action being taken. So let's get on with this one. What goes with that is the need for a New Zealand Services Graves Commission, or War Graves Commission if you like. The Commonwealth War Graves Commission doesn't cover very many service graves in New Zealand in terms of making sure that they're kept up a respectful state. Hence we've had the rise of the New Zealand Remembrance Army, a group of many thousands of volunteers who are cleaning and restoring service graves around the country, of which there's about 350,000, and these volunteers have done about 40,000 of them already. So good work to those fellows. The really damning part of this is that no one really knows how many there are. No one really knows where they are because we have no central registry, no database, and no national responsibility for looking after them. It's apparently the family's responsibility. Well, when families disperse and the links are broken, so too is the remembrance that these servicemen who have passed on deserve. Let's talk about the Defence Act. The Defence Act actually has an amendment bill that has been languishing since its inception in concept in the 2009-2010 Defence White Paper. There was a whole raft of changes that needed to be changed within, particularly the Defence Act, that have sat, and there's been supplementary audit papers, and there's quite material things in there, like changing the name of the territorial force to the reserve forces. Everyone's just talking about the reserve forces, but in law, the only reserve force that exists is the one made up of people who have served in the full-time force and then got out. That might seem to be a relatively minor thing to most people, but it's exceptionally important when it has knock-on effects into other legislation. There were other elements to that, like the changing of who holds a warrant in the service chiefs. And the warrant, remember, gives the person the right to go to the Minister or the Governor-General directly. Now, can you imagine a situation, for instance, in another ministry where a Deputy Secretary had the right to go directly to the Minister or the Governor-General and bypass their boss. Because that's actually the situation that exists in the New Zealand Defence Force at the moment. And there's historical reasons for that. So let's get that bill, get it moving, and do those mechanical changes that were identified as being needed to be done over 10 years ago. There's one particularly important part of the Defence Act that needs to be used, and that's Section 50A. Situations of national interest. Now, the reason why this clause exists is to enable the Volunteers Employment Protection Act, which is basically you can't be sacked if you go away as a reservist from your day job and go and serve the country here or overseas. To trigger the maximum protections of the Volunteers Employment Protection Act, Section 50A has to be used. It never has been. Unsurprisingly, there's been all sorts of troubles for volunteers and their jobs and their relationships with their employers. Now, it's a relatively simple thing. The mechanism already exists. All that the government has to do is declare under Section 50A of the Defence Act a situation of national interest. You'd think COVID-19 would be one, Operation Protect, wouldn't you? But it's not. And I believe that the legislation should be amended so that if a Section 50A declaration is made, then that should automatically make it qualifying operational service. At the moment, every single theatre of operations, Iraq, Afghanistan, East Timor and so on, has to go to the Minister of Defence, and they decide whether it's going to be qualifying operational service or not. That's clearly not a very sound way to do it. If the Section 50A announcement is made, it's automatically qualifying operational service. And what's different about putting your life in danger overseas and putting your life in danger here in New Zealand in a flood, famine, fire or so on event? People still get hurt, people still get sick, and I can tell you there's a lot more danger fighting a bushfire than a lot of the situations that our uniformed personnel are in some peacekeeping operations overseas. Now, qualifying operational service is an important legislative situation because firstly it triggers your veteran status, and that triggers your support both now and in the future, and it also triggers medallic recognition. And I can hear the eyebrows rolling out there. Yeah, $70 bit of cotton and a chunk of metal to hang on your chest. It's not much, but it's incredibly important to the people who actually go and put themselves in harm's way, because it's a public statement that they were there and they did that. It's been an ongoing source of problems as to what qualifies and what doesn't. It's never going to go away until we have a relatively simple triggering event, and I think that Section 50A of the Defence Act, situation of national interest, leading to qualifying operational service, leading to veteran status and leading to medallic recognition, is a no-brainer. And just while we're on that, it's not really a matter of national security, but I have written an article on my blog about a national emergency medal for New Zealand, and Australians have one, other countries do have something similar, and I think it's long since past that we should establish one here. And whether you're talking about the people who went onto White Island, Whakaari, or the people who went into the Christchurch CBD immediately after the earthquake and pulled bodies out of rubble and all that sort of thing, those people deserve some public statement, and a medal is a very simple way of doing that, and it's a way we could unite all our first responders, defence, police, fire and so on, one medal to bind them all. I mentioned the Volunteers Employment Protection Act. This was updated in the early 90s, and it was out of date the first day it was enacted because it creates all sorts of complexities that shouldn't exist, and a lot of these are connected to the use of Section 50A. So you've got some reservists who are completely protected under the Act, and some who aren't because there's no declaration. I've got a blog piece that talks about the Volunteers Employment Protection Act. If there's some really simple things that we could do better. If a soldier comes back from serving, say, overseas, and finds that their employer has not protected their job, and they have to go and find money from somewhere to pay a lawyer to bring the case. Well, the Defence Force has got a legal service, and the Defence Force has actually created the situation, so why on earth wouldn't the Defence Legal Service provide the legal representation to enable these people to get a fair deal? You'd be better off to get pregnant than deploy as a reservist right at the moment. You've got greater protection under the law. Let's just introduce the idea of voluntary national service, because it will require legislative change, but it is a huge topic that we're going to have to explore in another episode. In a nutshell, voluntary national service means you get something from the state in return for you giving up 1, 2, 3 years service in one of the arms or services of state. So not necessarily the Defence Force, it could be police, fire, ambulance, and at the moment we've got some version of this with rural GP bonding schemes. In a nutshell, if you imagine someone could say, look, I'm going to do 3 years in the army, and in return for that, their student loan will be remitted. So you could serve now, study later, you could study now and serve later, or you could do a hybrid mix of the two. It's not unlike, for instance, the American ROTC schemes. I think this will be an essential element for being able to recruit the right sort of people for now and the future. We actually had a scheme that worked perfectly well called the Malone scheme. There's still a scheme called the Malone scheme, but it's nothing like the original one that I designed in the mid to late 90s. We need to get back to some way of connecting society at large. How do particularly migrants come here and identify with our flag, our Commander-in-Chief, our nation's history and sense and all that? I mean, we don't even have a test to see if they actually know anything about our history, unlike many other countries, and I know that's being talked about. But voluntary national service is a real way that people could say, well, I'm new here, I came here when I was sort of 4 from, the country, but I'm going to give up some of my time and personal freedom to serve the country, because not only do I think that's a good thing to do, but there's some real tangible benefit for it, in that I'm going to be able to go and study a trade or study at university fees free. Well, that's a fairly fast overflight of the legal issues that I think we need to grapple with first. There's a lot in those, and as I said, I'm not a lawyer, but I hope to get some people who are lawyers on to talk about some of these in more detail in subsequent episodes. Thanks very much for listening. Don't forget to subscribe and tell your friends. That's it for this episode of Indefensible New Zealand. Thanks for joining the national security conversation. If you found this podcast episode useful, please subscribe and share it with your friends. For more information on New Zealand's national security, or to send in questions for the series, please go to my website, unclas.com.